Let me say how honored I am to be here. First of all, let's acknowledge that in any other sector, 1.5 billion people with unmet justice needs is a crisis. And I want to thank those who continue to work in the sector and who have been working in the sector that have enabled us to even think about people-centered justice. Nobody questions what that means anymore. It's in the forefront of our mind. And it's because of the hard work of people like yourself and others who have been for decades, David, working in the sector. I think that governments can learn from the public health sector, who, as you said, have moved from the hospitals as the center of service to making service being provided primarily in communities. So similarly, justice sectors can move from the courts as the center of service to communities and accessibility for people to have their problems rapidly resolved, to build trust in institutions and the other goals that you've enunciated. I think that we've come to a stage where we have to recognize that the regulatory environment is a primary step for governments. And David, I want to also add the UN as a part of the common agenda as we move forward to next year's meetings. But I would urge people to see in their mind's eye everybody being able to have a resolution to their justice problems. And let me use a very simple analogy. Travel agents. We can book holidays online, flights, hotels, tours, cars, all of those things. Travel agents are still thriving. So it's important for us to continue to keep it simple, and I don't think it's overly simplistic, for lawyers and those who are part of the institution of providing justice at the moment, primarily in people's minds, the courts, to recognize that new methodologies, new modalities will not mean that lawyers, just like travel agents, are going to not thrive. We will thrive. And doctors are thriving just because we have nurse practitioners or nurses' aides or physicians' assistants or community helpers in remote areas who are triaging and vaccinating has not taken away from doctors thriving and the need for doctors. In fact, it actually focuses them on to be actually specialists. I mean, you really need a doctor, you get a doctor. So I think that governments have to really focus on the regulatory environment. And I want to note that there are some governments that already have implemented regulatory sandboxes. They've become open to let's work with the private sector. Let's actually have PPPs that recognize the need for funding, the need for personnel, get the best people, that open doors for innovation, that enables pivoting so that we can scale up and maximize delivery on the demand side, as you have said, and all other necessities. I want to put on the table in the regulatory. I think governments have to focus on the regulatory environment. And I really want to put on the table this morning regulatory sandboxes. And the beauty of diversity means that that can mean anything that you want it to mean with the support of the government and the private sector in your relevant community or country.
It's great that you raised the sandbox approach, and we're going to hear from Natalie Knowlton later, who really knows her stuff on this. But let me press you a little bit on this regulatory environment question. If governments want to act, do they know what a good good in inverted commas, regulatory environment looks like? Do they know what to do if they want to encourage this diversity of supply? Is there a knowledge gap, or are the other gaps more around politics and vested interests?
I think it's a bit of both, to tell you the truth. And if we were to go back 50 years, I would imagine that when people were bold enough to think about, let's not have doctors be the primary provider of all health services. So when public health was being re-envisaged, they had to have the courage to recognize that actually we're not quite sure what is the best modality, or is there a best modality? Do we need to look at what is the cultural context, or what's the context in which we're going to be providing the service? So I think it's a bit of both. I don't think we can run away from the fact that most legislators are lawyers. And so there's a little bit of I hate to use the word cartel, but let's put it on the table. And so we have to just step out boldly, and let's focus on people-centered justice rather than protecting our institutions. It requires a lot of courage because it is change. It's immense change in a mindset. But I think that because most people understand what people-centered justice means and want people-centered justice, that the timing is impeccable.
Brilliant. And I think this provides a good bridge to Eddie Hartman, who I'm going to turn to next, because Eddie, you've launched some of the world's most bold and far-reaching innovations in the justice space, and I know that you've crunched into some quite powerful vested interests, as Alison slightly undiplomatically put it, the cartel that can control the status quo. What have you learned from your, first of all, give us a flavor of what you had to do to try and create the space in which you could operate, and what did you learn from that experience, and what do you think that tells us about further efforts to open up the enabling environment to allow the diversity of provision to flourish?
Well, David, let me start by saying that I'm an enormous fan of lawyers. I am a lawyer. My son, my firstborn son, is named after Clarence Darrow. I think that lawyers are some of our not only most intelligent people, but oftentimes some of our most big-hearted people who genuinely feel they're going to the profession because they're going to strike a blow for justice. I think the profession of law is an incredibly noble one, at least in the way that it is intended when one is a 1L or thinking about the pursuit of law. I think the reality of law, as it exists, at least in the United States and in the UK, is that I think necessarily it is regulated, but it is regulated almost entirely by market participants. And here lies the issue. We saw in the United States that dentists, taking the regulation of their own profession too far, were found to be in violation of our own antitrust standards. So when you have a market participant that is regulating their own market, you have to ask, in the case of the bar in the United States, do they believe that law exists to exert justice and preserve society? Or do they believe that law exists in order to provide an income to lawyers? Now, it's a bit unfair of a question. We need lawyers to be paid. They need to have a profession to follow. But if you would talk to the presidents of most state bars in the United States, if you got them in a position where they felt free to be candid, they would point to the fact that they're elected. Who are they elected by? Lawyers who work for a living, lawyers who would like their fees to be right where they are, if not perhaps a bit better. How can you expect people to vote against income when they elect the president of a state bar? And therefore, how can you expect the state bar to be against the remuneration of lawyers if that indeed is what must be curtailed in order to bring justice to more people? And so, David, you asked me specifically about my own experience. I like to tell people I'm the most deposed person that they've ever met. There was a summer, I don't know if any of you have had that summer where all of your friends are getting married. I think now that I'm as old as I am, I'm coasting toward that summer where all of my friends are getting divorced. But if you can think back to your 20s and that summer where it seemed like everyone was getting married, every weekend you had something to go to. I had that for depositions. I feel like I felt at the time there was not a single regulatory body that was not interested in hauling me in front of them, and oftentimes without ever having visited the internet companies that I had built and that others had built, merely upon research conducted by others or rumors that they had heard. So yeah, it was a period of firsthand experience at the ire of the bar. And I won't tell you any of the more salacious stories, David, although they exist. But it was a period where, at LegalZoom, which is one of the companies that I helped start, the definite feeling was that we were facing an existential crisis, that they really wanted to put us out of business. And some of them were polite enough to tell us that that was indeed the case.
So give me a little bit more of a sense of how LegalZoom coped with that threat, what the response was of the people whose job it was to think about justice for the citizens in the states that you were operating in, and how you tried to build support from them. And I'm also interested to know whether you began to get a kind of more public support as you build a growing number of clients, people, small businesses who were reliant on your services.
Great question, David. So the regulatory fight was fought and won by two wonderful friends of mine, Ken Friedman and Chaz Rampenthal. Chaz was the general counsel. Ken was the vice president for legislative and government affairs, as well as special legal counsel. So at the time, we didn't discuss this, broadly. The fact that we were every day fighting, at least for a decade, for our existence, and then, when it quickly became clear that we weren't going anywhere, fighting to preserve our business plans and allow us to expand, allow us to bring the benefits of modern legal services to more people. There's a constituency, though, that you didn't name, and I understand why you wouldn't, David, but the employees of LegalZoom had really very little idea of what was going on behind the curtain. And then finally, one day, the year was 2014, I urged Chaz to take a presentation that he was about to give, which was going to be the relatively bland presentation GCs give all over the world. And I said, turn it into a battle cry, turn it into a show what you've done, show where the fight has taken us. And Chaz produced an interactive map that to this day is quite famous at LegalZoom. He showed how state by state we were met with challenges, and state by state we met and won them, never shrinking, never falling back, always winning as we should. We were in violation of nothing, very careful to be so. He told how we had gone into states where the UPL, that is to say the unauthorized practice of law statutes, stated things like, it is unauthorized practice of law to do those things commonly done by a lawyer. A statute so vague. I mean, lawyers eat breakfast commonly. So what does that mean, really? But he showed us step by step how he fought from one end of the country to the other. And by the end, David, I am telling you, every person in that audience, every employee there was standing and applauding. I think people like to see a fight for justice. I think you can rally people behind it. I think people are asleep today. As Allison said, anything else, if this was medicine, with this number of people unserved, how could we not call this a crisis? How could journalists not be on this panel presentation? How could people not be moved to action? But sadly today, David, possibly because we haven't made enough noise about it, people are asleep.
Yeah, and I think this really comes back to the actual reality of these 1.5 billion problems. These are not trivial issues. This is somebody losing their house or embroiled in some, really difficult family dispute. I mean, these are these are life-changing, life-altering issues, issues for people. And I think we do need to start, banging the drum and saying these are as serious as, it's different, but it's as serious as the kind of burden of unmet health need, with which, so much has been done to try and reduce that unmet need.
We have Rebecca Sendifer in the audience, and I have to say on her behalf, I'm fairly sure that drum has been beating for a while, David. Maybe not loudly enough, but to say that we need to start beating it, I think does a disservice to people like her who,
of course, not.
Absolutely have been bringing that fight.
And I have Rebecca on my list to go to as soon as the panel is done. So we will hear directly from Rebecca on that. But first, we're going to go to Firas. Firas, you've heard Eddie talk about this fight for justice, and you're involved in that in a very different context from the United States. Initially in Tunisia, where Civitas Digital has been trying to build a bridge between the people of the country and the public services that they're struggling to find, and you're increasingly trying to take that model elsewhere. How have you worked with the government in Tunisia and with the formal traditional legal system, and how have you managed to carve out space in which you can operate? What kind of welcome have you had? What kind of obstacles have you faced?
Hello, everyone. I am surprised. I am amazed of the stories that I heard from Alison and from Legal Zoom. It's actually it speaks to me a lot, because what they are talking about is something that I lived, and it seems like this is all around the world. It's not something specific to Tunisia. We have faced the protective spirit or the protective mentality of the administrations. We have faced the sectorial or the sect-like behavior of collective or work collectives. We can call them unions, we can call them co-workers, whatever sort it is. We have also seen other things on the field that I would like to bring to light. It's actually what my co-founder Bashir always says, is the devil is in the details, but so are the opportunities. And in our case, we had the courage to knock on doors and to knock on these administrations, on these structures' doors, and with a friendly smile, we convinced them that we are not here to hurt them, we're just here to help them. And once you entered, we saw a very hostile environment. We've seen that close. But beyond that hostile environment, there is a lot of empty spaces where you can work, where you can exist without annoying or without, let's say, provoking anyone, until you are rooted enough to be able to resist their resistance. So that's what we did. We volunteered at first. We went to an administration and told them it's a municipality, and we told them that we are here to help them, and we are not focusing on the citizens. We are here to see your problems. I know that you have problems, so talk to us. Tell us what you are facing. And we have saw this mentality where the citizen is the enemy, and the administration is the enemy for the citizens themselves. And when in reality, no one is anyone's enemy. In reality, both of them have responsibilities and rights, and both of them should just keep it to the service provided. There is no need to create this tension. This tension for us, it was unexplainable. as a private company, private sector company. We are, you can say, we are more pragmatic than a citizen who is asking for a right, and for administrative administration who is trying to vet the citizens if he has the right to take it or not. But once you are there, once you are inside the administration, we saw the lack of resources. We saw their problems, and they do have problems. They are overwhelmed, at least for Tunisia's case, they are overwhelmed with work. They are overwhelmed with the lack of resources, with the lack of employees, with the lack of competence sometimes, lack of skills sometimes, and they don't have any way, they don't see any way out. They don't see, it's like they lack creativity. It's like they are convinced that this is the way to do it, and everyone should be satisfied with the work that we are doing. But once you give them the tools, once we showed them another way, we saw that resistance, and we saw that I'm not going to say hate, but skepticism turned into encouragement. They flipped the coin. They went to the whole other end of the scale. They weren't neutral with us anymore. They were encouraging us to build with them, to help them. They saw how the piles of file can transform into a screen, just a screen. They saw that the lines of citizens waiting in front of their office can turn into a line of text messages or a line of emails. And they saw that communication is actually easy when it is put in a scope. You can't talk to an institution. You can't explain to an institution your daily burdens and expect them to sympathize with them. At least that's what the administration was thinking. But after removing all the excess of information, removing all the stress from the work environment, we have seen the human inside the administration come to surface. We have seen that the administrations actually that are more reliant on humans and on feelings than an online shop, for example. You're only dealing with robots. And how to bring that human-centered justice to surface is by, let's say, emptying the hands of the people providing the service, make them concentrate on what they are there to do. Not moving files from an office to an office, not answering for where is my file, where is my request at, do you think I am going to get this service or not? These are distractions. We need to remove the distractions. We need to give them the resources to do their work, and we need to give them the way to control or to let's say to evaluate their work. We need to show them that their work matters. Most of the people, they see them as numbers. Administrations see people as numbers. At Civitas, we try to show them the numbers in a different way, where they can say that the work they are doing is actually making a difference. It's not, they won't rely on a citizen coming back to the administration and thanking them. They will see the platform, or they will see the statistics that show that their work is excellent and they are doing something to improve the life of citizens, actually.
So your service is, effectively trying to, as you say, remove the complexity between the person whose job it is to provide and the person who's looking for a service, and create a smoother, more human interface between the two. And you said that when you started, you went to talk to the people who had grappling with these problems, you listened and you weren't just selling them something, you were trying to find a way of solving a problem with them. But eventually this has to, generate revenue for you. So how did a business model emerge for this? Who pays, and how does this become sustainable in a way that it could be scaled?
So most administrative procedures are similar. You can categorize them, but what is different, what makes administration unable to let's say, have a software that is the same for every administration in the world, is that every administrations have different work procedures, internal procedures. The law is the same for every administration, but the way they execute it is different. So what we did is that we made something specific to our first municipality. And when other municipalities wanted to duplicate the experience, it didn't give the same result. So we went for personalization. And then we thought that if you give them an easy enough tool, they can personalize their procedures themselves. They can do the work for you, not for you, they will be doing them for themselves, actually. They know better. They know better how to deal with daily work. They know better what is easier for them. And you just have to put a certain set of rules so that the easier for them is not bad for the citizens. So we need to make it easier for them, and at the same time better for the whole experience as a whole. So our business model was based on this, actually, based on that duplicability of our system and its flexibility on itself. We have a system of managing roles where people can take other responsibilities than they actually theoretically should do. Why? Because most of the people working in administration, in fact, do things that are not responsible for doing. They are responsible for things beyond their scope. That is one of the reasons why I said they lack resources. They lack human resources and they lack material resources. But our business model evolved from there and went to a SaaS, let's say a distributed cost business model, where you will be paying, the administration will be paying for software that will help its employees do their work better. Before helping citizens get the service in a better way, it should at first make them make their work easier. If you convince that this administration will be giving its employees something to protect them, to make their life easier for them, we can let's say break or jump over the first fence, which is the protection mentality. The second thing is that citizens will not necessarily be able to use these procedures online. We know that online culture or internet culture is not something that is 100% of people in the world can do it, but there are many stakeholders other than the citizens and the administrations. There are middleware, there is lawyers for some cases, there are architects for some instance, for some procedures. And these people have major role in each procedure, and they are also protecting themselves, as LegalZoom said. You can't remove lawyers. The bar won't let you. You can't say this is an online way to solve cases or to go to court, and that doesn't rely on lawyers. That's impossible. No one will. You will face so much resistance, and we don't want disruption to be disruptive, just disruptive. We want it to be productive. We need to build on what we have. So in Tunisia, we had this example, or no, we have this idea of creating an administrative middleman. People who are already doing the work for the citizens, either for free or either for cost, and make their lives easier, make them provide the same services that they are providing for the citizens, and that the citizens are already paying for, but optimizing them, make them faster, make them better, make them connected with the tools that are inside the administration. With this will give you an ecosystem that is connected. The administrations have digital tools that are connected to the middleman, the digital tools, and to the service demander, or the citizens in this case, citizen tool. And there you can just relate everything. You can provide services from the middleman to the citizens without going to the administration, or you can go from the citizen directly to the administration. And this creates a digital administration that is accessible and that does not remove the human component from the process. We believe that the human component is the most important component in the justice field. You cannot provide justice without humanity. Justice is related to humans, after all. You cannot take justice, or a robot cannot provide you with justice. It's only a human like you that can sympathize and empathize with you, that can provide you with justice.
Brilliant. Thanks so much. And I think it's interesting that we're beginning to hear, just in the few contributions so far, the many different models that are possible in this space, from LegalZoom, which was essentially a business to consumer, or or to small business, so their customers were the people demanding justice, to Faris, who's gone to the administration and then built a network of middlemen as well. I mean, Bob, you're an impact investor. You've got experience in multiple sectors. You're now building a fund to invest in people centered justice. I think you're primarily, as I understand it, looking at newer companies in emerging markets that have solutions that you think can be scaled. I wondered if you could tell us a little bit about how you're setting this funding up, what kind of models you're looking to invest in, and also a little bit about the opportunities and the obstacles as you see them. What are the main things that are holding you back? Is it a lack of available finance? Is it these regulatory barriers and the risk that that they create, that we've been hearing about, or is it the pipeline of investable ideas and projects that you can put money into?
Okay, well, thanks, David. A lot of questions, I think, but all very valid in this respect. Maybe first, let me, for those who might not have attended it, yesterday was actually the launch, and I'm extremely excited to mention the launch of the Innovating Justice Fund, which is a cooperation between Hill and Found. And it's the first fund in the world basically focusing on SDG 16, basically on providing access to justice. So we're extremely happy to do that. Coming back to your point, David, I think the way we cooperate with Hill is that we will be providing fund management skills. So we will actually do the investments, but also work very closely with Hill for on the ground, hands-on sort of expertise, helping them working in the local environment, making sure they're investment ready in that respect, and having the linkages that are of importance. So it's basically a fund which is for a part investment capital, and the other part is more TA, technical assistance related. And we're really happy that the Dutch government actually supported us and to start with the fund. So we still have to grow, but we do have everything in place, and we can start making the first investments at this stage. it is something, I think, also if you look at the other sectors that we have been operating in, and we're an impact investment firm, but also an advisory in emerging market and developing countries only. So we only look at companies or sectors in those countries, because we believe there's a lot to be gained, and we're trying to sort of replicate what we have in terms of learnings to other countries and other sectors. This is the setup that you would typically see. So it's an investment capital, but at the same time also hand-holding, I think, guiding the potential companies. And that is always in addition to all other extremely useful work that is being done at political, economic, legal, and structural changes. But our approach, what we do, and we do it now jointly with Hill, is to really work also with the private companies operating in that space. And that's often in areas where governments used to or still actually have the claim to deliver those products and services. So we, for instance, have been looking at, the health sector was been mentioned before, but we've been looking at housing, we've been looking at water, at energy. Those are typically sectors where the government thinks that it's actually within their sort of span of control what they should be doing. And for whatever reasons there are, it's not going to all of the people there. So not everyone is sort of achieving what it should be achieving. And also in those sectors, you have seen that governments are opening up. It's step by step. It's also demonstrating that it does work. It makes it better. You provide more access to those services. And it's not working against the government. It's working with the government in order to get that access to the people. And I think that's something which we would like to demonstrate in this fund as well. And it's the only fund basically looking at SDG 16. So it will take a bit of time in that respect, particularly I think getting everyone known with people-centered justice, because I heard a couple of times it's known to everyone. Yes, it is known to everyone, I think, within this call, but if you look at impact investors, it might be slightly different, because I think a simple or relatively simple product as water and energy, or these are the things that are known and that also the investors know. And I think we need the time to demonstrate that also people-centered justice and access to that justice is something which can deliver an enormous impact, and at the same time is also worth investing in. So what we mentioned before also, I think with Civitas, it's important to see what are the business models, because in order for those companies to survive, there needs to be a long-term business model. We can help them get there, but I think that is also something which is vital. And in that respect, it is great that we're working also with Hill. Hill has been around looking at access to justice for everyone, basically, or user-friendly access, and has had, for instance, their accelerator program, which I believe is close to 140 sort of companies have been actually working with Hill in that respect. So I think in terms of the pipeline, there's an enormous amount of companies that we could be looking at. In addition to what Hill is doing, there are also other companies that are actually working in that space. But it's making sure that they get on the right track, helping them out, sharing between the potential investees of the fund, basically, what are the learnings, how could you apply it to your country, to your particular situation that you do have. And I think that is something what we're trying to do. And as it is the first fund, so it is also an extremely important element of what we're doing is the demonstration effect. It is showing that it can work. So this fund will demonstrate that access to justice can provide you impact. At the same time, actually, you also build companies with often game-changing sort of business models that actually are viable to invest in. So our role as a fund manager, as we do with the other funds, is, in this respect, also local with Hill and also local partner with Growth Africa, but also with our own sort of background and network. What we try to do is also make sure that they are viable and to go to the next step, basically, to be investment ready. So we will have the linkages with either local institutions, other institutions that can also provide the sort of funding to take them to the next level. So in that respect, I think there will be challenges, and that's what we like in a way. So that's good. But I think it's also the challenges that we can encounter, and these things work with partnerships. So I think the partnerships that we do have with Hill and the local people on the ground is absolutely vital. And again, there the local element is also about liaising with the local government institution. It's about also making sure that the whole ecosystem is going to be gradually changed in that respect. So the benefits of this approach, I think, is that you make also these companies with these game-changing models, you make them ready for investment, and you demonstrate it's something that investors can invest in. And I think that's what we try to do with the fund. It's will be the fund. What we always do is as it's called a blended finance structure, which basically means that there will be different investors. Some of them will actually just really think that the impact is important. Don't necessarily look at a lot of return on that side, which I think the return on every of this first demonstration fund will be relatively limited because it's the first one to go. And there might be other investors which are more impact investors, which really would see sort of a decent inflation plus return, but at the same time also really treasure that impact. And I think that is what the fund is doing, getting this money in, and really interested to talk to the investors that are willing to do that. We've seen it in the other sectors, as I said, because I think it's also a way for everyone involved in this and willing to make a change to be the game changer on the investor side in that respect as well, and really be the sponsor, be the one and ambassador of it. So yeah, we're extremely excited that this fund is now actually starting, and we will see some challenges for sure. And I think that's also been mentioned before. And I think on the regulatory side, it will not always be easy. We understand that. But it is typically that you see also in other sectors in these countries. And of course, it differs per country. But there is gradually an openness to cooperate with the private sector. So the public-private partnership does work. It's just it's more like a tailor-made approach in this respect. It's really finding the right way. And I think with the people on the ground helping us there, it's a setup which I think should work.
Brilliant. Thank you. Thank you so much. And we've now heard from a government perspective. We've heard from innovators who are trying to make it happen in the real world, and from Bob, what the investment picture looks like. And I'm going to begin to open it up to people who've joined this call. We want this to be an open, an interactive discussion as much as possible. And if it's okay, I'm going to come first to Natalie, who's at the Institute for the Advancement of the American Legal System, and who leads the organization, that organization's work on regulatory reform. And Natalie, we'd really like to hear your reflections on what you've heard generally, but particularly as Alison has mentioned it would be great if you could tell us why you think regulatory sandboxes offer one way forward, and give us a little bit of sense about what a regulatory sandbox is, where the idea came from, and how it offers a pathway to reform. So can't see you at the moment, Natalie, but if you are there, it'd be great if you could come in now.
Hi, yeah, can everyone see me? Fantastic.
I can see you.
Thanks, Eddie. Thank you all so much for allowing me to speak today. I really appreciate it. Hopefully I can add some value. So at ISLES, we do track regulatory sandboxes in North America. Just a brief kind of overview of where we are. Utah State in the US has the first regulatory sandbox, very quickly followed by a number of sandboxes across the Canadian provinces. UK currently has a law tech sandbox also focused on technology. And there are a number of proposals underway in the United States that may explore sandboxes in Washington State, California, North Carolina. Now, these efforts, of course, are not guaranteed until they are approved, but there is a lot of momentum around these vehicles. And just a bit about what they do. So the regulatory sandbox is completely agnostic to what goes in it. And they're very controversial in the United States, seemingly because of fear around what's going to come out of the sandbox. But the sandbox itself is a vehicle for experimentation, a vehicle for innovation. And in addition to the actual experimentation and innovation that it provides, the sandbox, the legal system often, at least in the United States, virtue signals around innovation and experimentation. And the sandbox gives us an opportunity to really put those words into action. We can test in a fairly controlled experiment while we're monitoring consumer harm in almost real time. For example, in Utah, the ratio of harm-related complaints to services is approximately 1 complaint per about 4,000 services provided. So we're starting to understand where the harm is and how we can mitigate some of that harm through this vehicle. We're also collecting additional information. Rebecca Sandifer, of course, is on the line, and she's going to talk, I'm sure, about some of the data that she is seeing. But for me, the issue of data that's coming out of the regulatory sandbox, first of all, we're able to look at harm from the baseline of the status quo, not some fictional baseline wherein there is absolutely no harm occurring. So that's one of the innovations that I think the justice system is committed to coming out of these sandbox models. It's also going to give us not only answers to whether these tools, these service providers increase access to justice, but also whether they are decreasing access to justice. That to me is the fundamental measure of failure when it comes to innovative service models and providers, not whether the companies are taking market share away from existing providers and maintaining levels of access in a jurisdiction. Although we certainly do want to increase access, the real failure is if they're decreasing access. So I just want to, plug the sandbox as being able to provide data on those potential metrics too. But the sandbox is allowing this private-public partnership between solving justice issues that, in the US at least, I just want to say we've already had this public-private partnership. And I think we gloss over it, and I think the US bar tends to gloss over it too. But the social contract between the courts as public institutions and the legal system as private and public players has always been that private attorneys will usher citizens through the publicly available courts and justice system. That contract has been broken for some time now, but the private sector still has a role in solution building to reinvigorate that social contract. So these regulatory sandboxes provide the environment in which those can flourish, at least in my opinion. And just a note about some of the innovations that we can see coming out of the sandbox. So the solutions are people, at least in the US, they're people oriented. So what kind of new providers are we spinning out? Are they not lawyers, but trained paralegals? Are we talking about technology? Are we talking about technologies that can bridge that diagnostic gap between legal information and legal advice? And we're also talking about new entities, new sustainable business models, which we just heard from in terms of the VC perspective on this call. In the US, venture capital has traditionally rewarded disproportionately white men. And there are a number of emerging VC funds and fund managers who are focusing on overlooked and underserved communities. And we're creating this VC pipeline for new diverse communities to come into the justice sector and create solutions. And the sandbox and experimentation on regulatory reform allows these people and entities to take on venture capital to put forward their proposed solutions, which I think is very important in diversifying solutions in the profession. And we're also talking co-ownership innovations that are authorized by these regulatory sandboxes. So how can entities and providers serve the human problem in a more holistic way that has a legal component as opposed to a singularly lawyer-focused solution? So I think I've probably rambled enough, but just to close, I believe regulatory sandboxes are a good way to balance innovation against the fear of consumer harm. Arizona, for example, decided to move forward in the United States on some regulatory reform without the sandbox. They just did it, and that's another solution too. But law is very risk adverse, and there are a lot of actually viable complaints and concerns that come out of the potential for regulatory reform that is unrestricted. So I think that these mechanisms really provide that balance for us when it comes to innovation and public protection.
Yeah, thanks for that, and particularly for that last point. I mean, there's a kind of theory of change embedded in the sandboxes and a kind of political strategy around that, which I think is what makes it such an interesting interesting strategy. I do now want to come to Rebecca. Your name's been come up already a couple of times on this call, and I think there are a few people that have done so much to gather and explain the data that shows the size of the justice gap. I was reading an article that I think you just published a week or so ago, which you titled "We Can't Rely on Lawyers for Every Justice Need," which pretty succinctly expresses one of the key themes of this call. And I wondered if you could say a little bit about how you think we can increase that diversity provision, particularly provision that's right down there in the community, serving very directly the justice needs of people. And back to Alison's description of this as a problem of monopolies and of a cartel. How can bar associations and others be persuaded to allow non-lawyers to enter their spaces?
Well, thank you, David, for the opportunity to talk about this a little bit. I mean, I think if you're thinking about jurisdictions like the United States, there are two main rule changes we would need to make in order to make it possible for services that are closer to people to be produced and consumed. And so one of them is related to the discussion of venture capital. So it's allowing people and organizations that are not law firms to make money from the practice of law, so to invest in it. And the other is to allow things that are not lawyers to practice law. And there are lots of ways to do that, as Natalie said. So Arizona just says, well, okay, we're going to get rid of the rules about outside investment and we're going to permit it in a particular way. Utah has taken a more experimental model, but I think the thing that I would emphasize about those sandbox-like models is that they are not only evidence-based, they are outcome-focused. So the question that animates the sandbox, what is the result that the person when they get help with their justice problem? And that's really the outcome that we're interested in. We're not really interested in how long people went to school or whether services are delivered by this kind of person or that kind of person. We're interested in whether that issue that someone presents is resolved in a just and lawful way. And sandboxes are focused on regulating specifically around that. And that's what I think is so exciting and hopeful about them.
Thanks, Rebecca. I'm now going to move to, if I can, to Mark Beer, who I think is probably in a position to complement what Rebecca and Natalie have said. I mean, Mark, you describe yourself as a lawyer, problem solver, and academic, and have had a broad experience in trying to shake justice systems up, whether that's in the UK or the work that you did to create a new type of court system in UAE with the Dubai International Financial Center courts, which created a new type of space for resolving business disputes. You're also co-founder of the fantastically named Deep Technology Dispute Resolution Lab at Oxford University. I thought I just had to give that a plug. But Mark, what have you learned from this experience of trying to open up justice systems? What can we take from the UK experience? What can we take from the UAE experience? What strategies emerge from that are applicable in other places?
Well, thank you very much indeed, David. And it's such a pleasure to be here amongst so many friends and colleagues, and hopefully new friends. And I've thoroughly enjoyed the conversation so far, and would echo and amplify everything that's been said. By way of example, we were blessed as a team to be able to create a new commercial court, pretty much a blank piece of paper. So we weren't held back by legacy issues. And within 10 years, we took a startup court to being recognized as one of the top 3 commercial courts in the world, recognized as the most advanced commercial court in the world, recognized as the most connected commercial court in the world. It was one of the happiest places to work across Dubai, and there were many happy places to work in Dubai, and that was across both survey done across public and private sectors. And we became the first court in the world to be accredited to the International Service Standards for Excellence, which is what hotels and airlines use to measure how well they're serving their customers, which also involved being the first court in the world to use mystery shoppers who were members of the public tasked with coming in with a problem and seeing how well we helped them and how they were treated. So within a decade, we were able to deliver tangible, recognized, accredited results by building a slightly different system. And our starting point was really to look at inefficiency. And if I may pick up on many of the comments, you know, this monopolistic behavior of lawyers, part of that is driven by the fact that their revenue streams are enhanced through opacity and inefficiency, or at least that's what they think. But coming back to it, what we first looked at is if we want to recruit the most brilliant people into our court system, which we did, the most talented, those with the greatest enthusiasm for justice and helping people, which is what a court needs to have. We worked out quite quickly that when you recruit these brilliant people, often out of the private sector and elsewhere, really committed to adding something back, when you ask them to receive bundles of papers or scan documents or all of those other wonderful tasks that take place in courts, they get bored very quickly. So the first sort of starting point was to say, hang on a second, why does a court operate the way that it does? And we looked through the rules of a standard court, and my thought process was, if we went to, if I bought a Volvo and it had a 2,500 page instruction manual, I'd probably consider it to be a pretty complicated and fairly difficult purchase. And yet in the justice system, we're happy 2,500 pages of rules or civil procedure codes and necessary annex, and not to mention the precedent that goes with the common law. But we think that's good, right? We think that's useful and user friendly. Obviously, the data suggests that it's not. So we started with the rules. And this was a point, I think, which amplifies what Firas was saying. You not only have to look internally at simplification and efficiencies, you have to look at the processes that the court is operating under and simplify those to the point at which you understand what is the role of the court. And the role of the court, in simple terms, is to ask somebody who has probably not been involved in the situation before, certainly wasn't there when the parties undertook whatever led them to court, very likely is not from the same socio-economic group as the parties, certainly wasn't involved in the email chain or the video that was involved, which has formed part of the court. And we're asking that person to come up with an answer because the parties themselves can't work it out for themselves. It's not a complex process. The complexity is getting the lawyers to understand which question they're asking the judge to determine. So looking at the rules and then bringing technology in, not for the sake of technology, for those who love Monty Python. It's not the machine that goes ping. It is technology that takes the drudgery away from court staff and away from the lawyers interacting with the court, take the drudgery away such that they can then focus on what they want to do, which is to help people. And we had on our bench the former Chief Justice of Malaysia, Zaki Azmi, a superb judge and also somebody who really loves the running of courts. And he told us in Malaysia, when he became Chief Justice, it was a desperately inefficient system. The number of cases that were backlogged was large, and almost every case was adjourned. And the lawyers loved this because they would be paid a fee to turn up at court only for it to be adjourned, and then they would go home and set another date. And one of his first rulings was no adjournments in my court. And he said to the judges, if you're with me on this policy of removing adjournments, then you will receive a significant pay rise. And if you're not with me and you prefer to carry on adjourning, then I've got a special court for you over there, and you won't benefit from my largesse. It was quite quickly adopted amongst the judiciary that there should be no adjournments. And the lawyers went absolutely crazy because they felt this would have a huge impact on their business model. And it's awful, isn't it, that lawyers built a business model which relied on the pain and suffering of the adjournment in the court. But anyway, that's what they thought. But strangely, at the end of the first year, when they asked the lawyers that had tried to depose the Chief Justice for such a radical change, actually they were making more money than they were before, up to 40% more money being earned, because they could take on more cases, because the cases that were coming up were going to be determined. So most of them settled and the lawyers got paid their fees. So actually from the court point of view, it's about demystification. From the lawyer's point of view, it's not so much, I think, about presenting change, it's about presenting opportunity. And there are plenty of examples where improving the system has led to more profitability for lawyers and law firms, and it's playing, I think, to that. And I think that the last point I wanted to make was we then started to think about the fact that so much money goes into court systems, yet as Hill has shown, they only serve about 5% of the population. 95% of the population wouldn't go near a court, even if they were forced. And the reason they give is, courts are for rich people, courts are for powerful people, courts aren't for me, etc., etc. So when I read about another billion, whatever it might be, being invested into the court system, I do wonder what's going to fill the justice chasm, the 95%, right? And almost certainly, whatever a court system does, it's not going to do much more over a decade than double its customer base. Maybe it can enhance public trust and confidence to getting 10% of the customers, let's call them customers, in need of judicial support. So the gap has to be filled, and I think that's where the private sector, and I love this fund, this is where the private sector plays a critical role. I'm not too convinced about this notion of a public-private partnership, because I think the end goals of the public and the private side are too far apart, particularly if it's going to be judicially supported. But I'm absolutely convinced that there's a large percentage of the population with problems who wouldn't go near a court, even if it was the most warm and customer friendly and user friendly place, but would use online tools that were provided by the private sector, almost certainly. And I think that's the huge opportunity for society to say, our courts are good at doing certain things, we've made them as good as we can, but we're still not going to serve the majority of the population. Let us invest in private sector development. And you may say, oh, well, this is really against the norms of justice, but arbitration has grown pretty well, hasn't it, since the 1920s, as a private sector dispute tool set up because the courts were so hopeless. Now the courts are vying with arbitration to be the best at resolving commercial disputes. So that private sector drives innovation in the court system. And my last point is it needs to drive innovation because the world as we know it is changing faster than ever. I'm not going to get into the privacy challenges that the Sycamore processor presents with now quantum processing commercially available and the end of encryption, because I think that's sort of fascinating, but not for today. But I am going to talk about the world of commerce being revolutionized by the use of smart contracts, which is, as you know, are self-fulfilling. So you don't need lawyers to be monitoring whether they're operating as the parties are meant to, and they're self-enforcing. So if one party breaches, the contract itself is the court. So smart contracts on the commercial side, and of course the ability for technology now to predict outcomes of litigation far more accurately than humans means that settlement rates are likely to go up significantly. And we know as a profession that the predictive tools now available are considered to be highly effective, purely by virtue of the fact it's now a criminal offence in France, imprisonable by up to 5 years in jail, if you use predictive tools on the French court system. So we can see that the institutions are feeling desperately threatened by the power of technology. And I think that applies just as much in smart contracts. So in summary, I think the courts have a lot of work to do in simplification of process. I think you need to sell opportunity, not threat, into the legal system. And I think that everybody needs to prepare, private and public, for what is becoming almost a tectonic shift in the way that the community does business and interacts with each other and deals with disputes.
Brilliant. Thanks, Mark. I can see that Teresa is trying to come in. Over to you, Teresa.
Thank you, David. A really interesting conversation. Very pleased to be able to follow it. I just want to come in with some additional points, maybe from a different perspective. I work at Hill, mainly at the country level. And some of the points that we hear coming up in our conversations are that strengthening the linkage between the formal and informal is really, really important. And I think it ties in really well with what Alison Gibson said when she started off, which is moving from courts to community will increasingly become the focus area for a lot of the conversations we're having with the formal sector in particular countries where the community means something very distinct and has also its own, sort of characteristics, and how strengthening the linkage between the formal and informal could actually be a way of reinforcing and putting back agency at the community level. So some of the things we hear are, for instance, what we need to be able to do is have the decisions made by the informal justice service providers validate, that there is some form to validate those decisions, that there is a method of record keeping so that there is some mechanism to go back to say that a decision was made on such and such a day between such parties, etc. So record keeping, archiving. Thirdly, of course, that ties in with enforceability of decisions. That will also increase in an uptake of those services provided by the informal justice system. And also, quite interestingly, we hear over and over again, don't regulate too much, because what you will then do is you will take away what makes the community modalities attractive in the first place. So when you want to get to, for instance, standardizing performance across the spectrum, rather standardize around principles and values, not rules and procedures. And if that could also somehow be woven into the narrative, there would be a lot more interest, both at the government level, but also in the private sector, because you're bringing the narrative much closer to what appeals in developing in the global South context. Let me put it there. So I'll end it there now. Thank you so much.
Brilliant. Thank you. Thank you so much for that, Teresa. What I'm going to do, we've got like 10 minutes left. I can see Alison's hand has gone up. What I'm going to do is give Alison the floor just for a couple of minutes just to react to what she's heard. I'm then going to attempt to summarize some of the discussion, and then I'm going to go back to each of the original panelists for a closing one idea for what they think is most promising to take this challenge forward. But Alison, over to you for a quick reaction.
Thanks very much. I just wanted to add that I think that what's going to also help, and that governments can focus on and support all that we've been talking about, is universal access to the internet. And the wonderful thing about that, from a government perspective, is that it applies to health, it applies to education, it applies to the legal sector. And so the expense of it, expense, is justifiable. It crosses many sectors. It enhances productivity and service to the people across sectors. So that is also something that governments, in my view, need to focus on.
Thanks, Alison. So an attempt at a summary. Sam was encouraging me to summarize this conversation. It's been so rich. It's not an easy thing to do, but a few things that have come out for me. First, it's been interesting how often the people in the system come up, and the fact that their jobs are often miserable, made difficult by incredibly old-fashioned systems, and actually there is an agenda here around liberating them. So the other side of people-centered justice, not the people who are seeking justice, but people-centered in the sense of the people providing justice. And there's clearly a theme there. Secondly, there's obviously a need to increase the diversity of provider and to provide more space for those providers who are in the system. I mean, I think people are often surprised when they hear about the experience of the UK to understand that the biggest provider of justice services in the UK is the Citizens Advice Service, and that's a volunteer led service. LegalZoom is a massive private sector innovation, so we have to increase that diversity of provider and begin to understand what roles that they can play. Third, I think we need to, what's come out of this call for me is the fact that we need to begin to be able to describe in much more precise and concise terms what the main features of a good regulatory environment look like. And obviously there's no one size fits all for any sector, and particularly not justice. But if policymakers are going to examine this question, they need some guidelines of what kinds of reforms they should be considering if they want to increase the provision of people centered justice. Next, I think that requires data. This has come up a number of times, but this is not the data about problems. It's, as Rebecca said, the data about outcomes. What solutions work? What kind of justice can they provide? Do they have adverse impacts and produce injustice? What's the value for money proposition? Are they equipped to go to scale? We have to start demonstrating that case with data. And it's not that data, that data often doesn't exist, but in cases it does exist, it's not necessarily getting to the people with their hands on the decision-making levers. I've lost the number of my points, but I think fourth, I think interesting points came up about trying to solve specific sectoral problems. So what can new approaches do, not just for justice as a whole, but for housing? And can a case be made that this can significantly change the nature of housing problems in a particular jurisdiction in a way that is attractive to a government, both economically and politically, and has a strong positive impact on society? I think taking it sector by sector is often going to yield promising approaches. Fifth, there's clearly the need for a new approach to finance. As somebody who was part of the long battle to try and get SDG 16 agreed, it's great to see a fund emerging to invest in SDG 16.3 and other justice targets. We need to promote these kind of new models, increase awareness of them, and begin to build excitement that a new financial approaches is possible. Six, creating space for experimentation. I mean, the sandboxes approach is such a clever way of, as we heard from Natalie, such a clever way of sugaring the medicine for very conservative systems and creating a safe space in which change can happen. So how can we kind of promote that kind of experimentation? And seventh, I think something that we learned very, very early on from SDG 16 plus, when we were beginning to construct some of the partnerships to implement, is that governments they're terrified of the problems that SDG 16 describes, but they're much more amenable when you start to talk about the solutions, and that when you begin to show governments what other countries are doing, you start to get a very different type of conversation. So beginning to compile the national experience, the national solutions, beginning to show countries what has been possible, and use that demonstration effect to get others to take it up. And then I know that that's the last point, but a last point, I think we then need to find some some powerful sponsors who can begin to get this new thinking into the mainstream. So is that the OECD? Is that the European Union? Is that the International Bar Association? Is that the United Nations, building on the common agenda process? Create some new norms, some new types of thinking, link it, I think, up to the SDG process and the SDG summit coming up next year, and begin to create a sense that a new paradigm for justice is fast coming. So those are some of my takeaways, but I'm just going to go quickly around the our fantastic panelists, take it in reverse order, and just one wish from you of something that could happen in 2023 that would begin to, free up the space, begin to take this agenda forward. So Bob, over to you. What are you wishing for? Do I have Bob?
He needs
Sorry.
to.
Yeah, it's working now. Yeah. Okay. No, I think it's already in one of your conclusion remarks. It's from my point of view, from the Innovating Justice Funds. I think there is, to demonstrate there is a new approach to finance. And I think it's a call to investors basically to make it happen with all the activities that have been going on and are still going on in this space. I think this is a unique opportunity to demonstrate that these companies with game-changing business models are basically investable in that respect and can really make a difference on the ground. So for ourselves, what I would like to see is investors coming in and increasing awareness. So this can only be a start of much more to come.
Brilliant. Thank you so much for that. And Faris, what's your quick wish for 2023?
As a startup, my wish is for supportive ecosystem. It's close to what Bob said. Actually, what we need, what I believe would really help in 2023 is support structures for innovative startups for the ODD 16 and financial structures that are willing to provide the necessary financial help for startups. As you know, we are not like classical enterprises. We rely on financing.
Brilliant. Thank you, Faris. And Eddie, your wish.
I think we need to have these meetings with people who disagree with us. That would be my wish.
Brilliant.
Wonderful seeing everybody. Take care.
Nice, concise one. And finally, Alison, the final wish to you.
I wish that legislators would look at the public health sector and recognize that non-lawyers can perform, quote, legal services. Non-lawyers can make money from legal services, and artificial intelligence can be well used to bring justice to people.
Fantastic. Thank you so much. I think that's a fantastic note to end on. I think this has been a rich discussion, hopefully the beginning of a new push to make this concrete and try and make it happen. I know that our colleagues at Hill are focusing on this for a big push over the next year. So really just falls on me to thank our panelists and thank the people who came in and responded from the broader group, to thank Hill for hosting this session, to thank World Justice Project for the technical work that they've been doing in the background that is hugely appreciated, our amazing translators who've been turning this into multiple languages, and all of you for participating. If you're here in The Hague, enjoy the rest of the Justice Forum. If you're not, please tune in to as many sessions as you can, and we look forward to being in touch. Thank you very much.